today. I'm going to go ahead and do an introduction for our speaker here. Today we have Kelly Twigger, who's the principal of ESI Attorneys, one of the first three.
Page number 8.
Excuse me.
It would make life
I'm sorry. So in addition to our online audience today, this webinar is being held live at Powwow, which is our annual customer conference. So we are having that in Indianapolis this week. And Nick, who is going to be joining us from Indy, so I guess he is getting set up, so I apologize for the disruption there. So as I was saying, I was talking about Kelly here. Kelly is the principal, excuse me for 1 second here. Sorry. She's a principal at ESI Attorneys, an information and eDiscovery law firm, and is the rare attorney who combines a love and knowledge of technology, the inner workings of business, and the analysis of legal strategy. Ms. Twigger litigated with Qualls and Brady in Milwaukee for 13 years before shifting her entire focus to electronic discovery and information law. She now consults with and advises her clients on navigating the risks of ESI for their businesses. As a consultant, she has worked with multiple Fortune 250 corporations, municipalities, and law firms to create programs for minimizing cost and risk in dealing with the complexities that ESI has thrown into the mix. She trains employees and board of directors on the risks inherent in ESI and best practices to minimize those risks. She's a frequent writer, blogger, and author of the Electronic Discovery and Records and Information Management Guide, published by VEST and updated annually. How are you doing, Kelly?
I'm great. Thanks, Rashmi. Thanks for having me today.
Well, thank you for joining us. And whenever you're ready.
Okay, terrific. Just logistically, so you know, I can see the control panel on my screen, so you can communicate with me that way if you want to. Welcome, everybody. Thanks for being here today. Thanks to my friends at Passageways for sponsoring this webinar and having me on today to talk about a very important topic. My areas of practice are really completely in electronic discovery and information law related issues these days. And my clients are around the country in a variety of industries. And what we want to do today is really my theme for all of you who are listening is to help you start thinking a little bit more strategically about electronic information. You're all on the call because in some capacity you have responsibility for information within your organization. And whatever the scope of that information is, this statement from Gordon Gekko is very much what I believe, which is the most valuable commodity I know of is information. And if you are young enough not to know who Gordon Gekko is, he was Michael Douglas's character in a very famous movie called Wall Street, in which information lifted him up and then took him down in the very end. So it's a very apropos quote, and I think, you know, the important thing today is that we want to start thinking a little bit differently about information. And this quote from William Pollard kind of takes us in that direction. William Pollard was a very famous physicist who worked on the Manhattan Project, which was the project that designed the atomic bombs. And the reality is that information is only useful when we can pull it into a form that allows us to see it. You've heard a lot about analytics in any context. If you use social media or you ever see anything about Google Analytics, that's a really generic example of how pulling information together is really important. And unless we can use the information that's created and leverage it, it's not of as much value. For example, if you're in an organization that constantly creates a marketing proposal every year for a particular event, and the person who creates that proposal keeps it on their hard drive, the next person who's supposed to create it, you're and that's a very simplistic example of what we want to do today. The goal is to really understand that information is created, really think about the technology information now. It's created, stored, processed, maintained, and how we have to do it. So and that kind of sets us into how lawyers are now going to deal with what we call
Hey, Kelly. Sorry, Kelly, the audio is cutting off for some reason.
audio cutting off?
No, you're sounding robotic, actually. I wonder if you could just, try now.
Okay, is this better?
No.
I
wonder if it's your mic setting.
Maybe let me try the telephone, see if that works.
It's a little choppy, yeah.
Okay, now I'm on the phone. Is that any better?
That is much better.
Okay. Okay, sorry about that for the challenges there.
Sorry, do you want to go like one slide before this one? I think we missed you there.
Okay. Let's see, I'm going backwards. Okay, so this we kind of segued from the William Pollard, but from this Bill Gates quote, what we talk about is the fact that in thinking about information now and being able to pull it together meaningfully in any kind of situation, we have to think about information technology and how that information is created and stored and maintained, and what exists of that technology or that information even when we think that we hit the delete button. And so those two notions, information and technology and business, that all come together really have to be thought about as one. And you'll see it a little bit as we go through this presentation, but a lot of what my consulting focuses on in helping organizations get plans in place to deal with information governance, ESI risks, and electronic discovery is to help them break down the silos between the various areas within the organization that can often have their own business goals that don't strategically align in order for these processes to work well together. So thinking about that, now let's transition to what we're going to talk about today, which is electronic discovery, and that is essentially what lawyers' role is with ESI. If you have dealt with litigation previously, then you know that discovery is the process by which we go and get the information from witnesses to a particular piece of litigation and understand what happened in that litigation. And a long, long time ago, as you can see from the slide, we used to do that in paper. When I started practicing, we would go to custodians and witnesses who were involved in the lawsuit who had information, and we would sit down face-to-face with them and say, okay, let's talk through your story, let's understand what happened. And they would reach in and pull a file folder out of their desk drawer and have all of the papers that were associated with that particular project. And it could be a whole drawer full or 5 drawers full, or it could be a small file folder. But nevertheless, we had all of that information right there. And different people would have different pieces of that information, and we would put it all together. But what we didn't have to do, that we now have to do with ESI, is to sift through huge file folders of information to be able to find what was relevant for that particular project or case or what pertained to that case. Now what we have is information that is spread across a disparate number of systems. So if I came to you and said, there's a breach of fiduciary case about the sale of this piece of our business that we engaged in 6 months ago, where would you have to go within your litigation IT infrastructure to be able to find all of the information that would be about that? Who were the 10 or 15 or 5 or however many people that you would have to talk to? And how many places would they have information? They'd have information on their email systems. They'd have information in SharePoint databases. They'd have information in spreadsheets. They'd have information all over, on hard drives, on networked areas, places where we have to really dig down into and not find just the one piece of information, but filter through everything that's there. So the difference now is that it's just a phenomenally different process, and lawyers have to really rethink how they're engaging in electronic discovery. And there's a lot of preparation that can go into businesses being prepared to deal with electronic discovery that can minimize the costs and risks associated with it. We still continue to have, and I'll show you here in a minute, a duty to keep the information that is required for litigation purposes. And because we have that duty to keep information, it means that we have to identify and collect all of that electronic information from the myriad of sources where it might exist. Think for just a minute about when you go and try to find an email in your inbox, whether you use Outlook or Gmail or MacMail or Yahoo or any other mail provider. When you go and search on your email, if you can't remember the right words to search for, then it takes you forever to find that email. And that's a very frustrating process. That is the exact process that we face when we are trying to find electronic information for purposes of litigation. And keep in mind that the lawyers don't know what the words are that the people who created the information have used. So we have to meet with custodians, have to start understanding that. And so it is a huge filtering process that we engage in for electronic discovery. This slide kind of outlines for you what is the biggest takeaway for you to go back to your organizations with in understanding the concept of electronic discovery as it matters for legal purposes, and that is that a party has a duty to preserve. That means keep any information that may be responsive when it knows about or reasonably anticipates litigation. And in the context of board communications that we're talking about today, you need to keep in mind that when your board is making a decision that they have been advised and that they know is likely to result in litigation, then any of the information that they create as a result of the decision that's made around that particular project is going to likely be discoverable information. And you need to think about that in advance, and you need to plan for it, and you need to think about how that information is being communicated as to whether or not it will be captured, i.e., is it in email, is it in instant messages, is it in annotations in a board portal, you know, where is it, how is it structured, and is it discoverable? So staying back just a little bit, thinking about the challenges that we face with electronic discovery and the volumes of ESI. And it is really that volume that is the huge problem, because the more ESI you have, the more cost you're going to be looking at in dealing with electronic discovery. And any steps that you can take to prepare, and we're going to talk about a number of those, are going to help you reduce the cost that's going to be associated. It's going to be very difficult to attach an ROI to it. So in order to be able to undertake programs where you put proper e-discovery measures in place before litigation or planning for changes to board communications, you need to have C-suite buy-in. You need to have upper-level management buy-in before you're ever going to be able to affect the kind of change you need to, because a lot of what you're talking about is rethinking communication strategies within the organization. Challenges in ESI are really the volume as it relates to cost, and also finding things across all of those disparate systems that we talked about. Some of the numbers that you see here, the 196.3 billion emails sent daily. I did a case recently for a client that has 12,000 employees, only about 3,000 of which are actually heavy users of email. And we pulled roughly 1 year's worth of email for those, for 15 custodians from those, 3,000 plus. For just those 15 people for a year, we had almost 50 million emails, because those are emails that are sent or received by those people for 1 year. That's a crazy amount of information to have to deal with, and when it gets down to it, ultimately we used about 200 of those within the context of the litigation. So how you get from that 56 million down to those 200, that's the process that we're dealing with in electronic discovery. Okay, so where do the eDiscovery rules come into play? So eDiscovery, the notion of electronic discovery came about in 2006. because the rules that govern what happens in federal courts are called the Federal Rules of Civil Procedure. And those rules were amended effective December of 2006 to provide that for a new category of information that could be discoverable called ESI, electronically stored information. And when that happened, the courts also provided, or the Judicial Committee that made the recommendations, also provided for some processes by which information would be discoverable. And so, but what's important here and what's important from your perspective is that those Federal Rules of Civil Procedure, which are now set to be amended again effective December of 2015, have now been applied in other contexts. So contexts in which the Federal Rules of Civil Procedure might not otherwise apply, but because they have laid out and there is such a solid case interpretation. So there's a lot of case law that's interpreted the way that the rules should play out. They're now being used to govern other processes like third-party subpoenas, regulatory responses, government investigations, DOJ second requests. Third-party subpoenas are specifically provided for in the rules, but there are some additional case law that has interpreted how those happen. So these rules and understanding the notion of eDiscovery, the duty to preserve, and the processes that we're going to talk about a little bit today are very important for organizations to understand generally. Even if you have a very small litigation portfolio or are not involved in litigation at all, it's important for you to understand them, because when you're a smaller organization or you have a membership, one large case could be the undoing of the organization from a cost perspective based on your requirements to respond. So the notion and the planning stages that we'll talk about are crucial to making sure that you keep those costs low. So now that we have a little bit of a background regarding the federal rules and what the notion of electronic discovery is, I want to transition us to thinking about eDiscovery of board communications. But what I really want you to understand is that if knowing the ins and outs of eDiscovery and understanding the nuances of the federal rules, i.e. how a party can ask for what form of information, form of production of information, all kinds of nuances like that. If those are key to you, we are not going to cover those today because that is a whole subject area that each one of those small bits can take up a solid hour. So we're going to focus today on the risks of eDiscovery and board communications, and we're going to do it at a bit of a broad-based level, but we're going to try and save questions, 10 minutes for questions at the end for people to be able to ask questions if they have specific things that they want to cover. So eDiscovery in board communications, when does that come up? In my litigation experience, I have seen board minutes, decision-making processes, what the makeup of the board was, what the votes were, lots of information like that be at issue when there's a decision by the board that becomes controversial in litigation, shareholder derivative actions, breach of fiduciary duty cases, and also pension fund cases, which are generally breach of fiduciary duty cases. And in those situations, actions taken by the board become discoverable. And the question becomes then, what is discoverable of the various types of information that are available within board communications? What is discoverable and what can you protect? And so what we're going to talk about now are kind of the risks that are all inherent in that. So our first risk is really what we've been talking about, which is not planning for eDiscovery. So, and let's talk about what that really means, a little bit of what we've touched on so far. So planning for eDiscovery really involves you pulling together the right people within the organization, analyzing the risks that you have, in particular in board communications. We're going to talk about this as a separate risk, but how are your board members emailing each other and folks within the company? Are they using text messages to communicate information? Are you providing information by emails, or is everything contained in your board portal? How are you handling specific functionalities of the board portal? Are they being captured? Would they be able to be preserved for purposes of eDiscovery? So in planning for eDiscovery, what you really want to do is within your organization create that team of people who brings together the right amount of knowledge. And we're going to talk about exactly what that is. With that team, then you want to sit down and identify and analyze risks, and then develop a process to address those risks that's right for your organization. Every company, municipality, entity, bank that I deal with is different in terms of what their goals are because their needs are different. A credit union has members and has to address the needs of the members. Other organizations have shareholders. Some organizations are private and don't. The risks can be different depending on those variables. They can be different depending on your litigation portfolio. Your process for planning for eDiscovery needs to be dependent on what your organization faces. Then you're going to develop that process, a little bit of which we'll talk about, and then you want to be able to implement and audit that process. Another part of what matters here is also training, which goes with the implement and audit part of the process. So when we're thinking about what is the goal of eDiscovery, we need to think about what are we actually trying to get to. So if you look at that big yellow circle on the left, I usually describe this when I'm talking on a stage as a dinner plate. If you think of all the information within your organization as a dinner plate, and from that dinner plate you have a shot glass that you turn upside down and put on top of that dinner plate. And within that shot glass, all that information that sits on that dinner plate, only the amount that fits in that shot glass is really what we consider records of the organization, right? In entities that are subject to open records laws, sunshine laws, Freedom of Information Act issues, their definition of records is broader because those statutes make them broader. But in entities that are not subject to those laws, where records is records and information, they're actual records of company business, company practices, that record subset is small. The green circle that you see there then is even a smaller subset of that shot glass, and that is what we consider to be the relevant ESI for a particular piece of litigation or a government investigation or whatever the issue is that we're focused on. And so we need to pull out that green circle. So the whole goal is to find that green circle from within the entire dinner plate. And that's the goal of what we're doing, and we do that by understanding our legal obligations to preserve information, filter in the legal strategy for that particular case, and then come to what the eDiscovery goal is for that case. And that involves a lot of cooperation and negotiation with the other side as well. Okay, so talking about creating a team, and I'm going to have to speed up a little bit because we are still on risk number one. These are really the four kind of areas that you want to think about within your organization. And not every organization, depending on its size, has things that are defined in this manner. But information governance, records and information management, someone from legal, someone from IT, business information services, information technology, whatever you call it, and someone from within the business that understands how all the information that's created works together for the business. Those people all have to come together successfully to be able to work through these issues, because if you have somebody just in legal sitting and mandating, here's how things are going to go, that's not going to work. It's not going to work well for the business. You need the business input on how things should work well for it. And so your goal is to create something that's going to work well for the business, but also minimize risks for the business. Okay, so what are the risks that you need to analyze, identify, and analyze? You need to think about the likelihood of litigation and regulatory issues, proposed legislation that might be coming your way that may impact your organization, past experience that you've had regarding electronic discovery, good, bad, whatever, potential exposure that the organization has, whether that's publicity or otherwise, and any impact on shareholders and members. So within those risks, you need to figure out what is it that your targets are, what are the things that you're trying to minimize. Everybody has all of these risks to some degree. It's just a question of what those degrees are and what steps you need to take to be able to mitigate those risks. So we're going to look now at a chart that is called the legal hold process flow. This is the process that I engage in as eDiscovery counsel with my clients when we have a new case. So when there's a new case where we receive notice of the litigation or we recently anticipate or we plan to bring litigation, then we have to engage in this process called a legal hold. And the whole idea of this process is where we preserve the information. We put a legal hold on information within the organization. We're glossing over this very quickly, but that generally is the process that we would follow, and that is one of the internal processes that I suggest that you come up with for your organization. Who will be the people who are responsible for managing and implementing that process within your organization or externally? So what are the processes that your team needs to develop? Records and information management policies and protocols, the legal hold policy and protocol that governs that process that I just showed you. The process for managing eDiscovery. You need to understand what your sources of ESI are within the organization. Generally, rather than creating what has been called a data map of the entire organization so that you know where everything is, what I want to understand are what are the sources of ESI that are created that generally are going to be important for the types of risks that you see. So if you regularly have employment litigation or you regularly have breach of fiduciary duty cases, then that's going to highlight for us what the sources of ESI are going to be. And you want to understand where those are, how you're going to be able to put a hold on that information, how you're going to get to that information, and where you can minimize costs associated for doing that. Selecting tools for handling data, that's generally for once you pull data out in the collection process, you want to review it, start looking at it, cull it down, and then start reviewing it. And then whether you have outside eDiscovery counsel that you're working directly with on the process. Okay, what are the consequences of failing to plan for eDiscovery? Well, we've talked about it. You are going to have exponentially higher discovery costs, and I really mean by the power of 10 to 20. So if I would normally spend $40,000 in preserving information for a case, then you can count that it will probably cost closer to $400,000 if you're doing it in what I call a Chinese fire drill. So you're having to do it very much on the fly. You're having to throw 10 people at it when you could have used 1 or 2 if you'd done it in advance, and it's going to cost a lot of money. When you have members and shareholders to answer to, those exponentially higher costs are not a good thing. Bad publicity, i.e. you don't do the discovery right, and you have plaintiff's counsel who like to go to the press, or I'll just take a high profile case that's happening right now, the GM ignition switch litigation cases that are going on right now. There are innumerable number of people sitting in rooms across the country looking at information from GM to be able to produce it to the plaintiffs. If there was a discovery snafu in that case, it's very likely that someone would go straight to the press to talk about whether GM was hiding the ball, not doing what they were supposed to do. So that kind of risk is something that you need to think about in advance, and you need to be able to deal with through processes. Regulatory violations, if there are governing statutes that require you to be in compliance with certain things that you're not meeting. And the last bullet there is sanctions, essentially would be levied against an organization by a court for failure to comply with their discovery obligations. Okay, so risk 2, and this is a big one, allowing your board members to use an email address that's outside the company. And we're going to do one of our first poll questions here. So I think Rashmi's going to send out the poll for everybody, and I'm going to keep going while you send out that poll. But really what we want to know is what are your board members using for email? Are they using their own personal email address? Are they using the company email address where they're employed? Or do they have a designated email address for the company board on which the member sits? If it's other than one of those 3 options, just pick the one that makes the most sense.
Okay, everyone should be able to see a poll question on your screen now. And Kelly, I'll just give it a couple of minutes for everybody to vote.
That's fine. I'm going to keep going just because we're short on time.
Yeah, we're not able to see your screens while the poll is going on.
Oh, you're not? Okay.
Yeah, we're almost there. Okay, I think all the votes are in. I'm going to go ahead and close the poll and read out the results here. Okay. About 53% said it's a personal email address, 27% voted for their own company email address, and 20% said an email address for the company on which the member sits.
So 53 personal, 23 own company email. And what was the last one?
Yeah, it is 53, 27, and 20% for an email address on the company on which the member sits.
Okay.
Okay, I'm going to go hide the poll. Okay, we are able to see your screen.
Okay, great. So let's, those of you who are engaging where you have your board members on your own company's email servers, congratulations. That is the best approach that you can take in order to safeguard your board members' communications. There is no, and I don't want to make any illusions about this, and if you're familiar with any of the cybersecurity issues and hacks that have been going on all of the major corporations, as well as this particular hack that we're going to talk about here, you know that, cybersecurity is not quite a myth, but it is very, very difficult, and it is a constantly moving target that IT professionals are engaged with. So while there is a lot of job security in internet security right now, it is a very difficult notion and a constantly moving target. In this particular instance, you may have heard about this. Michael Lighton, who is the CEO of Sony, used his own company email address to regularly correspond with board members from Snapchat, including Evan Spiegel, who is the CEO, CEO of Snapchat. And when Sony's email was hacked, Michael Lighton's email was released on the website, the WikiLeaks website, and all of Snapchat's business plans were released, including all of their super secret private information about what they were planning to do for the following quarter and also for the next 3 years. And it had significant ramifications for Snapchat, and there are a number of videos online that you can see where Evan Spiegel talks about, how that changed. And the one that was most compelling to me was the fact that he said he just went to his grandmother's house and cried for a day. So, these are pretty significant. It's a significant issue to be thinking about how your board members are communicating via email and where that information is residing. This is a very recent statistic. It is global. So about 43% of boards of directors are still sending information via email as opposed to using a board portal. If you are in the audience at Passageways and you are using the board portal there that Passageways provides, that is a great first step in securing communications for your board members. And for those of you on the phone who are not currently considering a board portal, you should. It is an excellent way to be able to provide materials to your board members in a once-contained form where you have control over what's distributed, and then you don't have to worry so much about all of these security issues. The board portal information, generally speaking, is encrypted. It is encrypted for OnBoard, right, Rashmi? And so that's a great process to undertake. Okay, so I want you to take just a second and look at this visual. If you're engaged in the planning and thinking about the risk assessment that we've talked about, and you're thinking about email and some of the other sources of ESI that we're going to talk about, you're going to see yourself being much more on the right-hand side of this picture than you are on the left-hand side. And that is a good place when you have to stand up in front of a court or a regulatory body or an agency and defend your position because you don't have information, because something wasn't retained according to a retention policy. If you can demonstrate that you acted in good faith, generally speaking in the courts, you will be able to escape sanctions. Okay, so moving on. Risk number 3, not identifying all of the sources of ESI that may be discoverable. And this, we're going to go quickly to another poll question. Rashmi, if you want to go ahead and send that out. And this question is, what is your organization's policy regarding the annotations made by directors in a board portal? So if you don't have a board portal, then obviously you don't need to respond to this because we're working with passageways there. Nick, if you can sort of take an informal poll among the folks who are there, here are the three kind of answers to the board poll. So either annotations remain on the individual director's portal and the company takes no action with them, the annotations are deleted by the administrator within a fixed time after the meeting is concluded, or the organization has no policy or procedure for dealing with them. And the annotations are the notes that a board member would make on the documents that are included in a board portal. So, you know, you essentially create notes just like you'd create a note on, say, an iBook or a PDF or something if you're used to using those features.
Okay, Kelly, I think I have the votes in. Well, never mind, they're still coming in. Give that a minute. Okay, the votes are in. I'm going to go ahead and close this poll. "57% voted that their organization has no policy or procedure. 40% said that it remains on the individual director's portal, and 10% said it's deleted by the administrator within a fixed time."
Okay, so those are good. Those are numbers that are fairly consistent with what I see in practice. And the question becomes, when you're policy making, these annotations are a form of ESI that your board members are creating when they're engaging. And if I'm a savvy lawyer who knows that you're using a board portal and these annotations may exist, I may ask for them. And there are arguments for producing them and there are arguments against. But you want to be able to think about that. You want to mull that over with your eDiscovery counsel and with your litigation counsel as to whether those need to be protected, whether they even need to be maintained once a decision is made. But they are written information that is ESI and is discoverable, generally speaking, if they're relevant and responsive in litigation. So you'll want to develop a policy around them. And that's just one example of sources of ESI that you have to think about. So essentially, your team needs to sit down and specifically as it relates to board communication, say, what are the ways in which my board members communicate either with us or with the rest of the world that may impact us? Do they have presence on social media? Do they text with other board members? Is there a reason why their mobile phone would ever tie back to the organization? You know, there are instances that aren't included in this presentation, but there are instances in which board members from prominent boards of directors have been arrested for DUIs and have videos released to YouTube from the body camera of the police officer because someone goes via a FOIA request and gets the video from the police department and then puts it up on YouTube, and then suddenly it's released. So those are the kinds of things that you need to think about and you need to be engaging with. It is a world where, in some ways, Big Brother is always watching because Big Brother is just about anybody. And cell phone video spreads faster than wildfire, and open records requests to municipalities and organizations, which is a lot of what I deal with, are very rampant, and they're used for any process in litigation that they can be. So these are a few examples of sources of ESI. You'll want to sit down and think about which ones are key to your organization. Social media in particular is very important, and one of the things that you'll want to know is how your board members are engaging on social media, because ultimately what your board members do reflects on your organization. There are a couple of issues here that you just don't think about. You know, this particular one here with about Donald Trump is actually a pretty funny one. Donald Trump tends to say some pretty crazy stuff on Twitter, and whether you're a fan or not of Donald Trump, it's usually pretty funny, the kinds of responses that he gets. I don't know if you recall when the gentleman was chosen to replace Jon Stewart on The Daily Show, that within, 3 hours maybe of the announcement that he was going to be replacing Jon Stewart, he was immediately called out as having a whole bunch of racist tweets in his Twitter account. And although they were deleted probably almost instantly after he came upon them or had to defend them, they had been screenshotted and shared around the internet in such a viral capacity that they live forever. The other thing to consider is that the Library of Congress now archives all public tweets. So every public tweet since 2009 is now a part of the Library of Congress. Whether you can successfully get that information via a FOIA request from the Library of Congress is still an open question, but all that information is there, so it's being captured. The last thing that's there is a really interesting Facebook case in which the daughter of a guy who sued his former school who terminated him for age discrimination, he settled with the school and was to get a payment for them, and his daughter, there was a very strict confidentiality provision in the settlement agreement, and his daughter went on Facebook and posted what you can see is listed there in the yellow box. And as a result, the lawyers for the school invoked the confidentiality provision and rescinded the settlement. And because that settled the case, that was it. He didn't have any other recourse. So email is really important. Other sources of ESI, very important. I want you to, if you're getting a grip here, I want you to start thinking about exactly what's happening in your organization and what you need to be thinking about. Some of you will say, oh, social media is a huge risk for us. Others, not so much. Risk number 4, not understanding how data is captured and stored. We're going to go through this one quickly because it's technical, and I know that a lot of people go, oh, I don't really want to understand technology, but what I do want you to understand some simple things. I have a device that I use that I can plug into most mobile devices, whether it's an iPad or a tablet or a mobile phone, and it will allow me to extract a complete listing of all of the data on that device. And these next few slides are some images of some of the data that you can see there. And if you see, in this particular case, you can see, if you look at the white tab that's immediately below all the blue boxes, you can see the SMS items. This is essentially all of the tracking of all the SMS text from the phone. So anytime, even though you delete a text on the phone, it still remains on the phone unless the phone is forensically wiped. So that is information that remains there. And if you can see all the metadata about it in the information, the dates that all the texts were sent, the numbers that they were sent to and from. And a lot of this information, we've used it a lot in litigation to be able to track or undermine what witnesses say or other pieces of information. So this is a blow-up of a particular text conversation from within those SMS items. And you can see that you get all of the little bubbles. So all those little bubbles that show up on your phone, I can pull them out very quickly, and anybody can with a forensic device and be able to see what's there. So education about what to communicate, how to communicate it. Clearly in litigation, not everything that is relevant, unless it's relevant to responsive, it doesn't need to be produced to the other side. But we've had many, many situations in which we've gone in forensically to examine computers for litigation for custodians and found things that were illegal, things that should not have been kept on company systems, and had to report those folks to authorities. So it's very important to start educating your employees and your board members about what these risks are, how they can happen, and how to keep themselves from setting themselves up for problems. This last image is just another one that shows us some more information about what was kept on that particular phone. You can see if you look at the top bar that there were a lot of text messages, almost 12,000 text messages, corrected texts, email, other MMS messages, contacts, calendar issues, the files, all those kinds of things. And then you can see that there's a time bar so we can track what the information was on what date. It allows us to narrow down communication at particular times. So those are kinds of more things that you need to think about with regard to sources for ESI. I used these mobile device examples, but this is very similar to what we can do with any type of ESI. And we can use tools to be able to filter down what we don't need and move to what we do need very, very quickly. So it is important, as folks who are responsible for information within an organization, that you understand some of how this works. And it may be beneficial for you to understand things in more detail, depending on what your role is within the organization. If there's, after this call, if there's ever a need that you have for education, if you want to reach out to me via email, I'd be happy to point you in the right direction to resources that I'm aware of. Okay, so risk number 5, failure to educate your board members on the risks of ESI. And this is a big one because, as we've seen a lot of these risks. We've got to help them understand where they can go astray. And oftentimes, board members are in the, I'm trying to remember my different generations, maybe baby boomers, who are, not as tech savvy and may be engaging with technology but may not understand all of these things. Frankly, anybody who isn't working in this space doesn't understand a lot of what I just showed you with regard to those mobile phone images. So understanding what you can and can't do and how it can impact the board of the organization on which you sit and the organization itself is very crucial for your boards of directors. And so here is kind of an outline of some training dues. And the thing that I have found in doing training is that in person with board members at a designated meeting time is the key time to conduct this training. They are there with their complete focus on this company they have prepared for by reviewing the materials that have been provided to them. It is what they're there for. Trying to do it on a separate occasion does not garner nearly as much success, not nearly as much engagement as it does doing it at the fixed time. Oftentimes, because you're talking about trying to address some changes in practices for communication, which are not often received very favorably, it is better to have an impartial third party having those discussions and then proposing them as changes so that they can be discussed among the board and the board can come to those decisions essentially on their own, but for the betterment of the organization. Attorney-client privilege can often be a good shield to be able to use if you can, if it's in the right context, to be able to protect some of that training so that it is not trotted out and used against you at some point in time. But again, the standard that the law requires is reasonableness across the board. So it's reasonableness in determining what you need to keep. It's reasonableness in production. It's not perfection, it's reasonable. So everything is with that in mind. The second to last bullet there is an important one because you need to be willing to discuss the positions of the board members relative to the inconvenience of issues for them. If they're using their personal email addresses and they don't want to have to keep track of another address, you may have to physically show them how they can do that. You may have to walk them through using somebody techie on their computer to show them how they can have a second email address. You may need to set up a forwarding for the email, something that will help them address those inconvenience issues. Versus risk management, the key example there obviously is the Hillary Clinton example that has been in the press of late. Training topics. I've made a list of these here. This is not a completely inclusive list of everything that I generally cover at board trainings. It is a pretty good start. If you're not familiar with bring your own device, that is absolutely a policy or practice that you want to address within your organization because, simply put, information for the organization that exists on the personal devices of board members or employees should be subject to the company policies. And most companies who are putting together active bring your own device policies and protections require that if an individual wants to use their personal device for company business and not carry two separate devices, then they have to be willing to have that device be able to be remotely wiped if it is misplaced. And so that's an important policy for you to be thinking about. There's lots of information available online, and I am happy to point you to those if you have not yet engaged in a bring your own device policy for your organization. It's something that also needs to be addressed with the board. Some of the other ones here we've talked about. So what are your takeaways? What's your homework? I think that all of these slides are going to be provided to the participants, so you'll be able to revisit this list. But it's essentially, go through those 4 steps of planning that we talked about. Create the team, analyze and identify and analyze your risks, put together the information that you need to for protocols, processes within the organization, and then, work through simple processes that are going to make a huge difference. When your employees leave, when your board members exit the company, what is your exit interview process for their information? That needs to be very key, because if you have a current legal hold that their information is key for, and they leave the company or leave the board, and you don't have a process in place to keep their information, then you may be at risk of spoliation and for sanctions in a litigation situation. One of the things I wanted to make you available of is some technology that we have that's available for providing assistance to organizations, and that is called the eDiscovery Assistant. It's currently available via the iPad, and it'll be rolled out for the web later this summer. It includes a lot of case law checklists and templates that are really a lot of guidance on issues in electronic discovery and things to be able to help with. And we've saved a little bit of time here for questions, so if anybody has a question and wants to submit it, now is the time. Rashmi, do you have any questions at this point?
Yes, we actually do have one question. Just give me a minute here to read that out. We have a question from Jay, and he wanted to ask you if you could discuss the concept of proportionality when applied to this subject, and in particular the applicability of these principles to smaller state court cases where there may not be a discovery as a matter of right.
Okay, absolutely. Proportionality is essentially the notion that the burden that one party has to undertake to provide information is not larger than the value that the information would provide. So if we put it in dollar form, if a case is ultimately worth $50,000 at its peak, that's the highest possible value of the case, and the party who was responding to that litigation or that was providing information in that litigation said that they had to pay $200,000 or $250,000 or more than that, then we would say that proportionality considerations would require that the parties revisit exactly what kind of information they're looking for in an effort to bring those costs down. And a lot of times what proportionality results in is a sampling of information. I'm not sure exactly what Jay's referring to in terms of a state where you don't necessarily have discovery as a matter of right. Maybe that's a particular area of case, type of case that he's thinking about. So if you want to give us some more information, Jay, I'd be happy to respond to that.
Yeah, hold on one second, Kelly. I'm going to go ahead and conference Jay in. Hi, Jay, are you there? Jay, can you hear us?
I maybe dropped that, Rashmi. Yeah.
Yeah, probably.
Yeah, so I'm not sure where there's not discovery as a matter of right, how you deal with proportionality considerations. If you are requesting discovery and you don't have any discovery as a matter of right, and the other side is arguing that proportionality precludes them from getting discovery or precludes them from giving you discovery, I certainly think it's a matter to either take up with the court or to try and address with the other side. What is it that you really need? What can you drill down to and get at a low cost that would help you understand better what other information might be responsive? That will give you a better case to make with a court, particularly in a state court where you're likely to have a less knowledgeable judge. We find that the lower down you go in the court system, the less exposure that judges have had to electronic discovery issues, and the less knowledgeable they are about those issues, even though there's a lot of training that's been going on. There is a very wide disparity among judges across the country in what their level of knowledge is about electronic discovery issues, rights under particular rules, what those rights mean, and even the concept of proportionality, although that concept has been around for a long time. Any other questions?
I don't see any. Again, everybody in the audience, you can use raise your hand feature. It's available on the panel, and I can conference you guys in, or you can even type your question in the chat window. We'll just give it a couple more minutes.
Yeah, that's fine. If after the show anybody comes up with the questions or other that they're interested in addressing, I put my contact information up there on the screen, and so you're welcome to drop me an email or reach out to me, and I'd be happy to answer your questions.
Wonderful, Kelly. I don't see any more questions.
Okay, great. Well, thanks so much, everybody, this afternoon. I hope this was helpful to you. If there's additional information that you're looking for, just reach out to me, and I'll see if I can direct you in the right way. If you're interested at all, I maintain a blog at our esiattorneys.com site that provides practical information on eDiscovery, and I believe a link to in the presentation for this will be posted on Passageway's site. Is that correct?
That is correct. That is correct.
Okay, great.
And thank you so much for this wonderful presentation, Kelly. I appreciate you taking the time. And thank you, everyone, for taking the time to attend this webinar. We will share the slides as well as a copy of this recording in the next few days. Thank you, and have a good night. Bye.